The chair calls Assistant Police Chief Ronnie Morris.
Good morning again. My name is Assistant Chief Ronnie Morris with the Grand Prairie, Texas Police Department. I'm here today representing, and I don't believe I included it on this one either, but if it could please be added to the record, Texas Police Chiefs Association and the Grand Prairie Police Department, speaking in opposition of HB 1178. I will just say that I did have some more visuals that I will spare everybody for sake of time, because I would like to drive back to DFW myself as soon as this is over. So appreciate all of your time. So House Bill 1178 would not effectively, it would make possessing drug paraphernalia in this state legal. Other bills before you today have sought to critically reduce penalties for certain drug possession, or in some cases decriminalize them altogether. You all now should have in your possession the drug paraphernalia policy of the Grand Prairie Police Department that went into effect in 2004. And I point that out to show that this isn't just something that we do because of the current climate today as it surrounds marijuana or other drugs that are being looked at to have reduced penalties or otherwise decriminalized. This is something that we have done in our police department for many, many years. And with this policy, all the police officers of the Grand Prairie Police Department are guided by this and mandated to abide by it, even when existing law allows for arrest. As you'll see if you read it, our first goal is never arrest, but instead stopping, removing the opportunity and prevention of crime and disorder. And that also goes back to the previous policy I provided to you on our misdemeanor arrests. So removing law enforcement's responsible discretion in enforcing drug paraphernalia laws is just another step similar to defunding the police in the slow dismantling of proactive policing that keeps our communities and states safe. Texas law currently allows officers the discretion of filing a lesser included charge of possession of drug paraphernalia in lieu of a violation of the health and safety code under certain circumstances. In removing this discretion by decriminalizing its possession, law enforcement would be forced to arrest individuals for state-level prosecutable low-level drug offenses where discretion currently exists for police to issue a citation or arrest for a Class C drug paraphernalia charge to be handled in a lower-level municipal court where sentence jail time is not an option. The visuals that I had would have demonstrated that all drug paraphernalia is not created equal, nor are they all just harmless tools. There has to be a better way to achieve what this bill is attempting to achieve without placing our communities in danger. And people who possess items that facilitate dangerous drug use pose a significant health and safety risk in all of our communities. I ask you all to oppose this bill and partner with law enforcement executives around the state and community stakeholders to draft legislation that addresses any potential inequities in current law while simultaneously keeping Texans safe.
Thank you so much. Members, are there any questions? Appreciate you. Appreciate you being here.
Thank you.
Ronnie Morris. That's Assistant Police Chief Ronnie Morris.
Good morning. My name is Ronnie Morris. I'm the Assistant Chief of Police with the Grand Prairie, Texas Police Department. I'm here on behalf of the Texas Police Chiefs Association and the Grand Prairie Police Department to speak in opposition of House Bill 99.
Assistant Chief Morris, I don't have you down for the association. Would you like for us to add that on? I just have you
If
down
you
here
could,
for-
please.
Okay, what is the name of the association?
Texas Police Chiefs Association.
Yes, sir. We'll make that notation. And what is your position on the bill?
I'm speaking in opposition of the bill today.
Yes, sir. Please.
So this bill, like several others being heard by this committee today, seeks to reduce the penalties for possession of marijuana and or essentially decriminalize certain small amounts of marijuana altogether by making it a fine only. Reforming the penalty scale for small amounts of marijuana may very well be the most reasonable and responsible course of action for our state right now. But to achieve responsible reform, you must be responsible in defining what small amounts of marijuana are and not be irresponsible by completely decriminalizing small amounts by making them a fine only. As public servants, our collective responsibility is to improve the quality of life in our law-abiding citizens, for our law-abiding citizens in our communities and make them safer, not to improve the quality of life of the criminal dealers in the communities that make our citizens' lives, quality of life lower and less safe. Again, I'm not opposed to reform, and I'm not speaking about compassionate use or even medical use. I'm talking about the criminal use of marijuana. But this bill, as written, is irresponsible. Some visual items I have here with me I think will reflect that pretty well, and I'll touch on that momentarily. Though no police departments or police officers are perfect, there are numerous police agencies in this state, including Grand Prairie Police Department, that are model agencies when it comes to equity and fairness in enforcing laws in a manner that is seen as legitimate and procedurally just by our communities. If you could look at the policy that I just had given to each one of you, you'll see what our processes are on minor misdemeanor and even Class C arrests. So instead of throwing the baby out with the bathwater, I urge this body to partner directly with organizations like Texas Police Chiefs Association, Texas Commission on Law Enforcement, and police chiefs around the state to enact statewide best practice policies like Grand Prairie Police Department's policies for all agencies whose policies don't necessarily reflect the most responsible approach. And we can make that a law in and of itself without throwing everything else that is good about our current laws out. And without partnering with police executives in the state to enact these changes, reaching responsible reform is most likely completely out of reach. So what I have right here, this is the third legislative session that I've come and testified on bills similar to this. And there's always a conversation on what is a small amount of marijuana. And a lot of people, you would be led to believe through a lot of conversations that are had that we're talking a joint. You know, someone discussed something earlier about, 0.4 grams in a brownie recipe and things like that. I would agree those are probably pretty small amounts. But what this bill seeks to identify as a small amount is this. This right here is 2 ounces. Now this, in all transparency, this is not marijuana. This is actually it's parsley, but it very closely reflects in scale and appearance as marijuana. But this is 2 ounces. So I don't think that I'll leave it to you all to decide whether or not you think that this is a small amount of marijuana or not. I do not, and I believe most people do not either. And this bill, if it were to become a law, you'd have to have an amount equal to this. This is 4 ounces before a police officer would even have the option of making an arrest in a situation when they come into contact with somebody who's in possession of this amount of marijuana. So I hope that this demonstration helps to show actually what a small amount of marijuana is being defined as.
Well, thank you so much. Members, are there any questions? Representative Crockett.
I did not want to have to ask questions, but I've got questions. You said you're in Grand Prairie.
Yes.
So, correct me if I'm wrong, Grand Prairie covers Dallas County, Tarrant County, and Ellis County.
Correct.
Okay. Now, I am from Dallas, and my DA has had a lot of talks about how much money Dallas County has saved because my DA is not prosecuting these, what I will call misdemeanor. I won't call them small amounts,
Sure.
misdemeanor, and you understand that DA Crusoe has declined to prosecute these misdemeanor marijuana cases, correct?
To a degree, he's declined first-time offender marijuana cases.
Okay. Let me give you some other information. He also informed me that in evaluating who was being arrested in Dallas County for Class A and Class B misdemeanors, I believe the number was approximately 90% of those people were actually black and brown. And of course, Dallas County doesn't just cover Grand Prairie, but you've heard testimony over and over and over about the fact that we're seeing a disproportionate number. And I'm just trying to be clear. You're not contending that there's not a disproportionate number of black and brown people that are being arrested for simple, I'm going to call it simple possession, because that's what we call it sometimes.
Well, I can't speak for the entire county of Dallas County. I work in Grand Prairie, which is partially in Dallas County. And Grand Prairie is also a majority minority city. So, you know, the bulk of the contacts that we have within our city are minority.
Okay, so in your experience, it's still going to be minorities,
Yes.
even if that's just kind of the general makeup. We've heard a lot about the defund the police movement, and there's been a lot of talk about law enforcement saying, hey, no, we need more resources. Don't take resources away from us. You'd agree with me, generally speaking, about that point, correct?
Yes.
With that being said, can you explain to the members on the committee approximately how long does it take to actually effectuate an arrest for a simple, and when I'm saying simple, I'm referring to misdemeanor marijuana cases. How long does that take? Is it 5 minutes? I see that, Rep. Kaysen has some marijuana. I smell it or whatever. 5 minutes later, he's in jail. How long? You got that loud. How long does it take on average? And obviously, it's gonna vary. But give me your number.
If you could just elaborate a little further, you're talking about from the point of arrest through prosecution, or how long it takes an officer to
not prosecution, just to effectuate the arrest, because you need to do a report. We've talked a lot about bail and
Right.
the information that a magistrate gets. So if you're doing an on-site arrest, that means you didn't have a warrant, so you're going to need to write up an affidavit so that magistrate knows exactly what went on, so that magistrate can determine what it is that they're going to assess. So there's a report that has to be done, so that's resources and time. You actually have to, I'm assuming you're going to frisk him and do some kind of Terry frisk. Make sure he's good, no weapons, things like that. You're going to handcuff him. You're going to transport him. And because this is an offense that is punishable by jail time, because we're talking about Class Bs and Class As, 9 times out of 10, you're going to county. You're going to take him to Lou Sterrett if it's Dallas, right? So you're going to drive from Grand Prairie to Dallas County Jail, which is downtown Dallas, which is, 25 minutes?
We don't transport.
Okay, so where you put...
Dallas County comes and picks up from our jail.
Okay, all right. So Dallas County helps you out on that, but that's resources. So that means that we're sending somebody out to come get Rep. Kaysen and then take him back. But can you give me an idea of the entire bookend process? Because, it's not quick. And if you pull him over in his car, which is where we get a lot of these possession of marijuana cases, you pull somebody over, you say you smell marijuana, that's enough for probable cause. You then effectuate a search, you find a blunt or whatever, then we got to impound the car. For law enforcement to argue that they do not have the resources that they need to effectuate their jobs, it is so hard for me to understand why we would not want to make sure that I want you going after the murderers. We got plenty of them. I want you going after any trafficker, any child sex. I want you going after that. I don't care if he's smoking weed, to be perfectly honest. If it means that I'm going to free up resources for you. So I want the committee to understand, I understand how much goes into effectuating an arrest. But if you could give them just a general idea, because they don't necessarily know how much time we're truly wasting and resources were wasted as we're trying to figure out how we're going to make sure you guys have what you need to keep us all safe.
Okay, first of all, I would challenge your premise of saying that it's wasting time. It's what the community members in our city tell us that is important to them and they would like to continue. But depending on the type of contact that we have, we're talking anywhere from 30 minutes to outer limits of about an hour of overall time for an officer to do that. But something else I would also direct your attention to is the policy that I passed out to you. You'll notice on the first page under Class C arrests, which is generally what the majority of our arrests for misdemeanor marijuana would fall under, because we generally go under the paraphernalia charge as opposed to the actual charge of possession of marijuana. There's several steps that
I'm sorry.
Sure.
I'm gonna have to interrupt you. So you're saying that your current policy right now is to essentially do what he's trying to do in this bill?
Now, if you could read the front page of the policy, you'll see that arrest is not our default for someone who has possession of marijuana.
Okay.
There's other things. Again, there's spirit of the law that we have to take into account. There's overall law enforcement objectives that we have to take into account. And very rarely in our case, in our city, does that account for an arrest.
I just want to clarify really quickly. You're saying that in many areas are doing this because of the unintended consequences of the legalization of hemp for some people. What they're doing is they're actually just dropping things down to Class C paraphernalia. So my question is, essentially, and the bill author can correct me if I'm wrong, but he's trying to take possession under 2 ounces, which is normally a B, and then classify it as a Class C. And if I understand your testimony correctly, right now, for the most part in practice, you guys are arresting people for possession of marijuana, but you're actually just charging them for the Class C paraphernalia on these cases anyway. So I guess I'm trying to understand the objection, because this would be essentially doing what you're already doing.
Well, it's actually not the same, because it doesn't take into account, actually the bill as it's written now would take away our discretion to be able to make that decision. Plus it also wouldn't allow us to take into consideration prior history of a person that we're in contact with. Obviously that changes the dynamics. If we are in contact with a person who has, half a dozen previous convictions for possession of marijuana, chances are we're not going to go with the possession of drug paraphernalia citation charge.
Okay. Thank you.
Members, are there any other questions? Thank you so much for being here. Thank